The clarity hearing scheduled for August 15th, 2023 at 9 a.m. We have prepared an agenda, so have you had a chance to look at the agenda?
Yes.
So we get a motion to approve the agenda.
I'll make a motion to approve the agenda. I'll second that.
Any discussion? All those in favor? Aye. All those opposed? None. The agenda would be approved. First thing on the agenda is to approve the minutes from the June 6, 2023 meeting. Those have been provided. I don't think I was at the meeting.
I'll make a motion to approve the minutes. Second.
Thank you. Any discussion? All those in favor? Aye.
Aye.
All those opposed? None. Motion carries. The minutes would be approved. That brings us to why everyone's here today, I guess. Good morning to all of you. As you all know, we are here today for a recall clarity hearing. The Newaygo County Election Commission is determined by state law. That's us. Consists of me, the probate judge, the county clerk, and the county treasurer. My name is Melissa Dykeman. I am your Newaygo County Probate Court Judge. Jason Vanderstel is to my right. He is your county clerk. And Jason O'Connell is your county treasurer. As I indicated, we are the members of the County Election Commission. That is determined by statute, and that is why we are here today. The purpose of the meeting today is held under the Open Meetings Act and is meant to comply with the Michigan election law, specifically MCL 168.952 as amended.
On August 4th, 2023, Mr. Joshua Stein, a registered voter of the city of Grant, filed with the Election Commission petition wording to recall Rachel Gort, Ken Thorne, Richard Vance, and Sabrina Belkamp Block from the Grant Public School Board. The petitions read as follows. We, the undersigned, registered and qualified voters, city of Grant, in the county of Newaygo, and the state of Michigan, petition for the calling of an election to recall Rachel Gort from the office of Board of Education member, Grant Public School, for the following reason. On June 19, 2023, Rachel Gort voted in support of issuing a 90-day termination letter to Teen Health Center Family Health Care, otherwise known as the Child and Adolescent Health Center, to terminate the partnership. Next recall petition. We, the undersigned, registered and qualified voters of the city of Grant, in the county of Newaygo, and state of Michigan, petition for the calling of an election to recall Ken Thorne from the office of the Board of Education member, Grant Public School, for the following reasons. On June 19, 2023, Ken Thorne voted in support of issuing a 90-day termination letter to Teen Health Center Family Health Care, otherwise known as the Child and Adolescent Health Center, to terminate the partnership. Next petition. We, the undersigned, registered and qualified voters of the city of Grant, in the county of Newaygo, and the state of Michigan, petition for the calling of an election to recall Richard Vance from the office of the Board of Education member, Grant Public School, for the following reasons. On June 19, 2023, Richard Vance voted in support of issuing a 90-day termination letter to Teen Health Center Family Health Care, otherwise known as the Child and Adolescent Health Center, to terminate the partnership. Final petition. We, the undersigned, registered and qualified voters of the city of Grant, in the county of Newaygo, the state of Michigan, petition for the calling of an election to recall Sabrina Belkamp Block from the office of Board of Education member, Grant Public School, for the following reason. On June 19, 2023, Sabrina Belkamp Block voted in support of issuing a 90-day termination letter to the Teen Health Center Family Health Care, otherwise known as the Child and Adolescent Health Center, to terminate the partnership. That is all.
The Election Commission set this time and date to determine, as the statute reads, whether each reason for the recall stated in the petition is of sufficient clarity to enable the officers whose recall is sought and the electors to identify the course of conduct that is the basis for the recall. As you can see, our function today is very limited. We do not determine whether the reasons contained in the petition for recall are sufficient or adequate. We do not determine whether the stated reasons are true or false. These are questions of a political nature confided exclusively by our Constitution, Article 2, Section 8, to the electorate. We only determine whether each reason for the recall stated in the petition is of sufficient clarity to identify the course of conduct that is the basis for the recall. In other words, each reason for the recall in the petition must clearly contain stated facts, not conclusions. It must furnish adequate information so that the officer involved and the electorate are able to identify the incidents and substance of the claimed misconduct. If a recall sponsor alleges 2 or more reasons for the recall, each reason must be judged for sufficient clarity. If it is determined that all of the stated reasons for the recall are of sufficient clarity, the sponsor may proceed with the circulation of the recall petition. If it's determined that even one of the stated reasons for the recall is not of sufficient clarity, a determination of insufficient clarity is required. The sponsor of the recall would then be free to resubmit the revised recall language or appeal the County Election Commission's decision to the Circuit Court. A recall petition may not be submitted against a public officer during the first year or the last year of the officer's term, if the term of office for the officer whose recall is sought is 4 years. The reasons for the recall, as stated on the recall petition, must be based upon the officer's conduct during his or her current term of office.
There are certain guidelines governing our determination as to the clarity of the language in the recall petition. These guidelines include the following. The recall petition must clearly state the charges so the officer can identify the incidents, prepare his or her justification. The recall petition must be clear enough to inform the electors of the specific character of official conduct relied on for the recall. As petitions are often drafted by laypersons, it would be too great a burden to require a meticulous and technical detailed statement of charges. General charges of a conclusionary nature which do not identify the transaction are insufficiently clear. And where the clarity of the reasons stated in the petition is a close question, doubt should be resolved in favor of the individual formulating the petition. These are the guidelines taken from the Michigan Court of Appeals and will govern our considerations today. Our determination today, therefore, will simply be whether or not each reason for recall stated in the petition is of sufficient clarity to enable the officer whose recall is sought and the electors to identify the course of conduct that is the basis for the recall. The Election Commission will make that determination on each reason stated in the petition. As previously mentioned, if it is determined that even one of the stated reasons for the recall is not of sufficient clarity, a determination of insufficient clarity is required.
Both the proponents and opponents of the recall will be permitted to state their respective positions concerning the issue of clarity of the petition language. We request that you confine your comments to that issue only, as clarity is the only issue to be decided today by this Election Commission. When addressing the Commission, please identify yourself by name and address. Is there anyone, well, should we start with the opponents or just go?
Oh, yeah, I'm sorry.
All right. I think we'll start with the proponents. So, Mr. Stein, maybe, do you wish to speak?
Thank you, Your Honor. Joshua Stein, 259 Exchange Street, Grant, Michigan, the sponsor of the petition.
Thank you, sir.
I understand that the purpose of the hearing today is to determine the factual and clarity nature of the petitions. I do believe the petitions speak for themselves and can enable the voters to have sufficient clarity of the conduct of the board members to enable them to issue their opinion on the language. I did submit evidence in support of the petitions. The June 19th school board meeting would refer to a motion by Rachel Gort, supported by Sabrina Belkamp. The language states to issue a 90-day termination letter to Teen Health Center, Family Healthcare to terminate partnership. My language amended the language from the meeting minutes to Teen Health Center might also be known as the Child and Adolescent Health Center. That's what some people know the facility as. I also submitted, and in this June 19th hearing, we have that Rachel Gort voted yay, Sabrina Belkamp Black voted yay, Richard Vance voted yay, Ken Thorne voted yay. Additional evidence submitted was the June 30th special board meeting. And in this meeting, there's a motion by Rachel Gort, supported by Sabrina Belkamp Black, to approve the agenda and board minutes from June 19th, 2023, which solidifies the action of the June 19th meeting. And just as additional clarification, a partnership is a legal relationship existing between two or more persons contractually associated as joint principles of business. To support is to argue or vote for, and to terminate is to bring to an end.
Thank you, Mr. Stein. Anyone else wish to speak? Any of the officers or public wish to speak? Now would be the time.
Good morning.
Thank you, sir. Good morning.
I have some information for you if I can bring it to you.
Thank you, sir.
I apologize for my ignorance. I don't know if I have an opportunity to object, but it's my understanding that any evidence needed to be submitted at least one day in advance of the meeting. So I'd like to object to any documentation submitted because I didn't have an opportunity to request and review that.
Well, that's a first.
That's not, where is that in the law? I
Let
didn't see that.
me check the statute real quick. I do.
Okay.
So, the information, of the day before, does that come from the state?
I was gonna say, I don't see it in the statute.
This from the state guide for clear hearing?
Okay.
The state said that this is the only requirement for their hearings. We discussed that with them.
So, Mr. Stein, I'm gonna allow him to provide that, and I will give you a chance to review. Why don't you come up, Mr. Stein? I will look at what affairs. All right, sir, can you state your name for the record?
Absolutely. My name is Ken Thorne, 11-5-12 Elm Avenue, Howard City. So in the packet that I gave you, there's, several pieces of information, but because, what we are actually talking about is the language, I would go back to, the board minutes for, June 19th, and, yes, that motion was made, that motion was voted on, it was added to the agenda. The very next, packet of information there is actually a transcript of the motion that was made in that meeting. I would point out that, the motion that was actually made was to terminate the contract, not necessarily the partnership. So, I realize that the meeting minutes do say partnership, that would be an error in those meeting minutes that we did not catch before we approved them. So, that is, further evidence of that, honestly, is that we are currently in negotiation to, create or get a new contract with this health center. So we do not have the intent to, terminate that partnership at all. The June 30th meeting, that meeting, did solidify the actions taken at the June 19th meeting. That meeting was actually held, because there was a challenge to the posting, per the Open Meetings Act on the June 19th meeting. So, the June 30th meeting, no, the June 19th meeting, was a meeting that we, by law, had to have our budget for the school passed by the end of the month. Because that challenge happened, we held a special meeting on June 30th, and there was one motion to ratify all decisions on the June 19th meeting. So that is the further, vote that happened on June 19th. The last, piece of information, that I have in there is simply, a copy of an email that shows that we are, in current, contract negotiations. So this is a copy of an email from the school attorney to the CEO of Family Healthcare, where our attorney sent a contract to them for review, and per reply, we have not heard much more since then, but we are very hopeful that we will bring this to a conclusion.
Thank you, sir.
You're welcome. Any questions that you would have for me at this point?
I don't think so.
Okay,
Thank
thank
you.
you.
Anyone else wish to speak?
My name is Springwell Camp, 880 North Canada Road, Bailey, Michigan.
Thank you.
I didn't make extra copies. I do have a, copy of the statement that was released by the school board on July 23rd of 2023, going over, releasing a statement that we are going into negotiations with the Teen Health Center. Can I bring one of this up for you to see?
Do you have another copy?
Yes, I have one more.
Can you give one to Mr. Snyder for me? Thank you.
Fix that. Also, council, I'm not, I have confidential information that is given to us per closed meetings. I can't release the information to anybody but you per what my attorney said, so I don't know if it's standing or not. So before I get into what you'd be seeing, I just wanna know if that's relevant to be able to hand over to you.
So as a board member, or as a board, you went into closed session,
Yes.
and you believe that some of that information in the closed session would be relevant to today?
Yes, it's part of our safety concerns, and we actually, our school district does what's called a secure education consultant, where we have a party that comes in and audits our security. And there was a site made on that that's listed in it, that I can't go further with besides to you. So if that's something I can show you, I would like you to see it just so you can see some of the security negotiations that are being made as well.
I don't think,
Okay, that's fine, I just wanted to
I
make
wanna
sure.
make sure that we're, being careful
Well, that's why I
about things
asked,
that
because
we're.
there's a lot we can't
Yeah.
really discuss, that's a concern as well, and I would like it known that, we're doing our best, we're working right now on security and making sure that our school is very secure for our students, and that was one of the things that wanted to be listed on that contract as well, that isn't right now.
I appreciate that. Thank you.
And then, just one more thing that I had, during the beginning of our move where everybody got reseated, committees were made that were supposed to be 2 to 3 per committee. The health center going on as one, and when that was created, it was created to only reflect one member sitting on that was supposed to report back to us, and we weren't reported back on anything that was happening. I do have the list of the committees made that show every committee but that one was listed with multiple people on it. Can I bring that up for you to see? Sure.
So for clarification, you're talking about as a board, there are certain committees each board member is placed on?
Yes, and there's supposed to be 2 to 3.
Okay, thank you. Mr. Stein, did you wanna see a copy of that? Thank you. Thank you, Mr. Stein.
And then my last, and I'm not doubting that you did not see it, but in our contract, it clearly states that either party, being them and or us, have a 90-day notice, written notice to give them, termination notice, and they can do the same as us if something's not working, to review, renegotiate. There are 2 standing contracts right now. One that went back to 2011, and another one that I believe it was recent, don't quote me on the year, but I believe it was 2022, that was put through without board approval. So we need to be in conjunction with one. Right now, there's 2 standing, one says one thing, one says something different. We're just trying to bring that together to make one contract that states all our concerns for the safety of our students, the rights of our parents. That's literally all we're trying to do.
Thank you, ma'am.
You're very welcome. That's all that I have. Any questions for me on that?
Thank you.
Thank you. Do you still have the copy of that?
I do.
Thank you very much.
You're welcome. Anyone else wish to speak today?
Good morning.
Good morning.
Rachel Gord, 1717 Canada Road, Michigan.
Thank you.
With me this morning, I have, an audio recording, it is on this USB, of the June 19th meeting, stating clearly the motion was made to terminate the contract, not the partnership with the health center. In that audio recording of that meeting, it does state the reasonings. As my cohorts have also mentioned, safety concerns which were spoken about during a closed session meeting, and also multiple violations of their contract that we have with them. I'm not sure if you'd like this USB of the audio recording, which that transcription came from. But if you have it, or if you'd like it, I can give that to you.
That is also the, Mr. Thorne, I think, provided that transcript,
Okay.
right?
Yeah, I just didn't know if you
Yes.
wanted the audio version of that as well.
No, I think we're good with just the transcripts, thank you. I think we're good with just the, typed up transcript of it, that'd be great, thank you.
Thank you.
Anything else?
Any questions?
Thank you.
Thank you.
Anyone else wish to speak today?
morning. My name is Lindsay Malish. My address is 6704 East 112th Street, Howard City, Michigan, within the Grant School District. There is one thing that I would like to point out on the June 30th, 2023 minutes that were already submitted. As it was already stated, at that time it was voted and approved to confirm the agenda and board minutes, which solidified the actions of the June 19th meeting. I do also want to call out within those meeting minutes that have been approved that a motion was brought forth by Rob Skidema to rescind the decision to remove the health center. So I do think as we talk about transcripts or wordings, being that this motion was brought to the table and voted a nay vote by Rachel Gort, Ken Thorne, Richard Vance, and Sabrina Black. If they had concerns with the verbiage, it should have been addressed either in the discussion of that motion and documented or prior to them approving and confirming the minutes of the June 19th meeting. Any questions?
Thank you. Anyone else wish to speak this morning? All right, no one else volunteering to speak, I guess we move on to discussion. So again, the issue is clarity and factual clarity, not whether it's true or false or justified or the reasons behind it. So I see, in the petition, it says terminate partnership. I think, obviously that's what a number of the witnesses today were trying to get at. And in the minutes, it says terminate the partnership. And obviously, in the transcript, it says terminate the contract with Teen Health. So I guess that's really, in my opinion, what we.
Yeah, when I look at that, with that is kind of under the vote for consideration, we vote whether or not the reason is sufficient clarity to enable the officer whose recall is sought and the electors to identify the course of conduct that is basis for the recall. And it's a partnership, it's approved partnership.
Mm-hmm.
Is that something that's going to confuse the voters by reading that? I guess that's my thought is at the moment.
Also, do we have to look at the term of office for some of these folks?
I was wondering.
No, that's something that's, you don't have to worry about.
You did.
Yeah. Not, what you're mentioning there is not all members are recalled, can be recalled at certain times based on what we talked about with it, the year before and after, where somebody was appointed, same type of thing. But they can still be submitted, so when it does come to that point, then they can circulate the petitions at that time. As long as it's within the 180-day window.
I think for me, that, like you said, the question is it clear enough so the officer knows the incident to prepare his or her justification, and so the electors know the specific conduct that is the reason for the recall. And I think even with the difference between partnership and contract, to me, I think they're clear in that regard. I don't think that difference causes them to lose their clarity or cause the electors any confusion as to why the recall's being asked. Obviously, they all have their reasons and they continue to move forward, it looks like, with maybe creating another partnership, or creating another contract. But I think, again, we're just here for clarity, and I think based on that specific moment, we don't look at what's happened since or how they've tried to change or adjust, so I guess those are my thoughts.
Yeah, and even, this is when there's a doubt of a close question, doubt should be resolved in favor of the individual formulating the petition as well, so I think that, speaks to the partnership
Versus
versus
contract.
contract.
Mhm. I think, the other point on the June 30th meeting minutes is that they approved those minutes, and the agenda, and then also, Mr. Skagama, his language was rescind the decision to remove the health center, so I think that, the overall concept, whether it's remove them, partnership, contract, I think the electors know, based on the